of all, more people seem to be arriving. So, yeah, just a final verification and we can start. So thank you very much, Ryan. Thank you very much, Sam, for accepting our invitation. As I said, the main goal is just to allow people to ask you a few questions, both about your scholarship, but also about collaborating with someone on a similar or the same project. And so, yes, so I have received a few questions via email. I imagine people in the room may have other questions as well. So you can jump in. If you're shy, you can use the chat. And if you're even, more, uh, if you're shyer, you can use the chat and send the question directly to me. And I promise not to say who you are. But yes, perhaps the first question for you both is a very easy one. So perhaps if you can tell us before we discuss your collaborative work, what you have been doing? What's your current research project or projects? Sam, perhaps?
So together we've been working for many years now on constitutional theory, and have toyed with a book that would put different articles together, but actually haven't discussed that lately. So we've really been working article by article. And then we each have our own, agendas separately. So I have just finished a book about American gerontocracy, and dabble in other things. But certainly in recent years, the collaborative work with Ryan has occupied a very central, place in what I've been spending my time on.
Yeah, beyond most of my time has been devoted to the project with Sam on courts and constitutionalism. In addition, I have a sort of ongoing interest in conservative legal thought in the U.S. So I've been doing a bit of that, and obviously that's a rapidly evolving area. So yeah.
Curiously, I have been for a few, I think I have the job I have now precisely because or thanks to my work on conservatives in the 60s and their arguments against civil disobedience. So, yeah. So, yes, perhaps now, if you can tell us a bit more about the projects or the project you are developing together. Sam has just mentioned a series of articles that will eventually be published as a book.
Yeah, I could say that. And so, our work together sort of began with a basic sort of shared skepticism about the outsized role of the judiciary in the US. And relating to that, the centrality of constitutional argument in particular in American politics. And so that's been kind of like the animating interest or skepticism behind the work. And then in terms of like specific pieces, I think in many ways, because it's been such a rapidly developing political situation, I think sort of doing these sort of discrete pieces that are addressed to very particular practical concerns, I think has been the way that the project has evolved, right? Starting sort of early on when there was this sort of, for the first time in half a century, a sort of robust debate around the role of the Supreme Court. We wrote like a more schematic piece trying to sort of articulate and situate different approaches to reform. Later projects have been more responsive to like more specific critiques that our project has received. And now, and sort of a lot of the work has been around court reform in particular, but we've also done a bit of thinking around the area of constitutionalism and again, the centrality of like constitutional rhetoric and constitutional argument. And that is obviously very sort of salient right now as we look to the response to the second Trump administration. So much of the rhetoric has been in the register of sort of, constitutional crisis, but also sort of, respect for the Constitution, things like that. And so that I think is a particularly sort of relevant notion now.
Yeah, I'd agree. I mean, I think, Ryan and I have done really from near the start some journalistic work together that's in many ways outrun the scholarly articles, of which I think we've done, you know, three or four together, depending on how you count. And you know, those articles were, I think, you know, sometimes envisioned as occasional, like our very first one, democratizing the Supreme Court. Um, but at the same time, kind of, you know, taking a breath and looking as deep as we could rather than trying to address the public, you know, in any immediate way. So that means that we have like this fund of op-eds and things on which we haven't like, you know, we haven't fully substantiated them in scholarly terms, and you know, we might, and some of them become more relevant at different moments, like our New York Times piece just arguing against constitutionalism is not something we've ever argued in a scholarly way yet. But it is super relevant, maybe far more relevant than our court reform articles to date, just for the current moment. But I expect, you know, that the court reform work will be super relevant if and when Democrats win elections again.
And how do you decide, together or not, when to write an op-ed? Is that some, I don't know, one of you realize there is actually something you might address in the public sphere, or are you usually invited by, I don't know, newspapers or magazines to write these op-eds?
I have been invited once or twice to write op-eds, but I've never dragooned Ryan into those occasions. Maybe I should have, but I think, you know, the ones we've done where we really thought it was propitious to say something, and yeah, so we shop them around, or you know, we've generally gotten, it's been easy for us to place these op-eds overall. And I think that's because we really were trying to speak to a current moment. And I think it just depends on each one, like whose idea it was initially, and um, yeah, who framed it and whatever.
And I received many questions in this past 3 days about how you concretely write together. So does someone start and the other, you know, continue? How do you usually work together on producing the manuscript?
Yeah, I mean, so usually I think we have worked from sort of work with like a shared document to create an outline for both full length academic pieces, op-eds, and then within that sort of divide section by section. Obviously, Sam and I have different disciplinary backgrounds, right? I'm a philosopher by training. Sam is a historian. We're both lawyers as well, but but I think often like our arguments sort of try to sort of blend those sort of methodological approaches, and so and at least much of the time there is a sort of natural, I think, division in terms of like who takes first crack at which section, and then have a sort of iterative editing process from there.
Yeah, I would just add it kind of depends. It's kind of case by case. I mean, there have been, you know, I would say of the four we've done scholarly pieces we've done, two really were completely collaborative. Like we really each we kind of did an outline together, divided the work, revised one another's parts. I would say two others, maybe because one of them, which is forthcoming, was more intellectual history, and the other was more, let's say, you know, democratic theory. We each kind of took the lead on those, and the other edited. But our you know, our most cited piece, which is also the first, democratizing the Supreme Court, that was written, you know, over a summer of like trading back and forth a document, and each writing sections for the other's inspection. I think more recently we've had like, yeah, less like rapid exchange and more kind of writing sections and showing whole sections. Whereas the first one was kind of an interesting experience because it was like, what did you do? I think we keep different hours, and like I was working in the early morning, and like I was like, oh, what did Ryan do last night? And then I could add, and so.
So you have a common file like I don't know, Google Doc one? No.
For the first one, sir, we did. I think it was on Box, if I am I recalling correctly, Ryan, or
Yeah, I think, I
and
mean,
it
we
was like
whether,
renumbered versions of the same document or something like that.
yeah, yeah.
And then others like were the two I mentioned that were more like one of us taking the lead, I think were shared at like an advanced state of preparation. Um, I mean, it's true that I probably like it's true that he's a philosopher and I'm a historian, but I also think like I also sometimes have the role of rhetorician, like he's the more Socratic one, and I'm the more sophist figure. So I like sometimes do more work on like framing and things like that, even for the one that Ryan largely wrote. So
I know perhaps that's a very specific and a very French question, but coming from the Department of Philosophy in France, your work, Sam, is usually read as philosophy slash history of philosophy. So I'd love
yes.
to hear more about perhaps, how you both see, you both are lawyers, but one is a historian with, I don't know, perhaps a in a French tradition, you might be seen as a philosopher as well, and the other one, perhaps, if I understood your path, Ryan, you'd be a more analytical philosopher. How you see these two perhaps very different approaches to philosophical thinking in your work, in your collaborative work?
Yeah, it's a really interesting question because it's true that like by training, I'm an analytic, come from the analytic tradition, whereas Sam's training is in the more like critical theory, like that sort of philosophical tradition. And so it's interesting where those sort of where those differences come out or not. Because in many ways, like my as a sort of thinker, my methodology is more squarely in the analytic tradition, and yet my politics I think fits much more naturally in the critical critical theory tradition. And so in that sense, I don't find it very discordant. Um, I think the one, I mean, major difference, and I think, and to be totally frank, I think this is a shortcoming of analytic philosophy, at least as it's taught in the US, is that Sam's theoretical reasoning is much more historically grounded than mine typically is. I think my reasoning is much more grounded in like contemporary writing on theoretical topics. And so that's really, for me, it's really wonderful to just learn the sort of historical sort of origins of a lot of the ideas that I'm working with in the context of a contemporary literature.
Yeah, totally. I mean, it's a great question. I would say, our narrative in intellectual history in which I was trained is that, we kind of unfairly were forced to provide shelter for certain philosophical traditions while the card-carrying philosophers like excluded them. And so it's not been hard for me, at least subjectively, to transition to the kinds of projects that Ryan and I do, which are really less historical and more theoretical. However, it's also true, as Ryan said, that really can't write in con law without a substantial historicist sensibility because there's so much that has happened that you really like have to understand as, historical and path dependent, and also as ideological, that I think you can't even attempt to engage it in good faith in the way that you might if you were just a kind of mainstream analytic philosopher. So, but I also think analytic philosophy is being pushed hard in a more political direction, and like the deep concern of a lot of analytic philosophers like Sally Haslanger and Jason Stanley and so forth with the problem of ideology attests to the importance of that sheltering role that like the my teachers were trying to play, for these leftist intellectual traditions. And so it's great to be able to combine forces, and I agree there's not a lot of tension.
Yeah, so many people would like to hear from you about whether they should perhaps go to law school after finishing their PhDs. So how do you see, how was the path navigating law school? And I don't know, Ryan, whether you did a PhD as well.
Yes, I did a FOSSI
Yes, so
PhD.
perhaps if you could tell us, you know, what do you, I don't know, for example, how did constitutional law shape your scholarship? Or how difficult it was law school vis-a-vis a PhD program?
I can go first. I mean, so I did the PhD first. I came straight from undergrad into the PhD program, and then from there into law school. So I did it sequentially. So it took quite a long time. Um, and I found, on the one hand, like I'm very pro, if I'm pro JD PhD programs for people who are already interested in the PhD. I think both the reason why I decided to go to law school is that I was doing a dissertation completion fellowship at an interdisciplinary center here at Harvard, and the person running the program at the time was a legal theorist, and he persuaded me during that year that being a law professor was just a much more interesting, rewarding line of work, largely because of the practical impact that you could have as a legal scholar, as opposed to he had also contemplated being a philosopher. And so I think on the one hand, and that has definitely proven true, for better or worse, law professors are afforded a great deal of respect in sort of popular political discourse, and so that's been really wonderful. And then the other, just to be totally like frank and pragmatic about it, is that there continue to be jobs in the legal academy in a way that there are very few in humanities fields. And so for that reason, like coming back to Harvard, which is my was my both for law school and the PhD, my home institution. Been doing a lot of work since coming back at trying to build the connections between the department and the law school for precisely that reason. I just think it's almost professional malpractice for humanities scholars in particular who have legal interests to not contemplate that formal credential connection. Just because I think without that credentialing, it's incredibly hard at this point to get a law teaching job. And then the other is if having the JD provide certain alternate career possibilities that even a PhD person well versed in legal theory, but without that credential, like obviously wouldn't have.
Right. So my story is a little different, mainly because I'm a lot older, and there was a jobs crisis, or we thought there was, in around the millennium when I got my PhD, but that it was nothing compared to now. And so my own choices were more motivated by just uncertainty. And so I did half of my PhD in Berkeley before I decided to. I wasn't sure I wanted to be a history professor, and then decided I would try law school. And I honestly was horrified by it. So I decided I definitely would finish my doctorate. And it's kind of almost an like accident that I finish my law degree as well, because I didn't have plans to be a law professor, um, and and wasn't for half of my career at this point, or more than half still. So yeah, but I agree with Ryan that like from early on in law school, you understand, or even before, that a law professorship is just very different, not only in the sense that more exist for you to try to get, especially now, but you have access to more, formative role over, potentially significant people in politics, but also, yeah, access to, the public square for whatever good or bad reasons. So I think there are a lot of virtues, not just vices, to legal academia, but they maybe they weren't as apparent to me as when I first encountered it through like witnessing Harvard Law School 1L classes, having gone to Berkeley for a few years. And now I've kind of reacclimated to just have, because I've spent now 10 years as a law professor, gotten more assimilated by the profession than at the start.
Yeah. I should also say I found law school very challenging, especially coming like from the PhD. It was so much more regimented and felt so much more intellectually constrained in a way that I found very challenging and frustrating. So it's complicated because I think on the one hand, I think being a law professor in many ways is much more liberated because it's a multidisciplinary
Right.
sort of area of scholarship, and so there are far less constraining disciplinary norms, which can for better and for worse, but it really provides a tremendous amount of intellectual freedom. Whereas being a law student, I found like enormously frustrating. And so that was, that one should be aware of that downside, especially coming from a PhD setting.
Yeah, there is a related question about what have been for you the challenges of publishing in law reviews vis-a-vis, academic journals in the humanities. And I think it's related to what you have just said, Ryan, about the constraints, perhaps, of law school.
Well, I mean, it's so different, right? I mean, and I don't think like I mean whether it's disciplinary peer review versus student edited in the US law journals, like very different um terrains and like with their own pathologies. But I think especially if like for us, if you're doing work that has obvious like practical or political obvious practical or political interest, I think a real virtue is that student edited journals, basically the bar is if you can convince law students that what you're doing is interesting, like they will publish it. And again, like that can result in a lot of bad scholarship being published, but it also provides a lot of like freedom that I think trying to get similar types of arguments through peer edited journals that are gate kept by very senior figures is much more complicated. So in that way, I think it's a real site of opportunity to really sort of depart from sort of existing norms about like what types of arguments are considered in bounds or not. And so in that sense, I think it's been really um, good. And the other thing is just the timeline. I mean, like the response time for student edited journals is like incredibly fast. It's within a matter of weeks, maybe, month or so, versus, many, many months in the peer review context.
Yeah, I don't have a lot to add. I mean, honestly, I had not basically published in law reviews before I began to do so with Ryan. So um, I was not that familiar with the process. I don't think I had submitted one just like over the transom through whatever the system is called. I forgot already because we haven't done it lately. At any rate, like, but it's not to me. We write books as historians. Not that we don't publish articles, but it's true that the articles are in peer-reviewed locations. So, I mean, it's been really educational to work with Ryan in this regard, and I've really enjoyed it. And I agree that it does give you more immediate gratification. Also, it tends to be published more quickly, but it does require you to do a pretty enormous amount of work at the time of submission to make it seem formally adequate. And a lot of that isn't required, at least for history journals, where like the proportion of footnotes is minimal. Even in a discipline like mine, where you're actually having to prove certain facts, it's just there's another level of obligation even to submit. And then there's just a lot that I was required to learn about the formatting of things, and which is just different, like blue booking, which I personally never learned. So it wasn't easy, but it does have some, it's the space. So if you want your ideas to percolate in these expert spaces that law professors work in, even if no one else is involved or aware of them, which is true. Like it's a requirement, and so it's been really interesting to learn new tricks and or try to and prepare these articles.
So there is a question, an anonymous question from the chat box about how did you first meet, if you can say.
Well, I mean, I knew of Ryan as an up-and-coming legal academic, and I hadn't read his work honestly, but I assumed he was a conservative because of he was publishing with one. And I mean, I have subsequently read that work, but I'm just talking about my own initial impression. And that, but then we kind of interacted on Twitter, and uh, we met up at a bar at one point. So I don't know. We really had an intense summer after that of writing this democratizing the Supreme Court piece, which I think had a big effect on both of our careers and changed what we publish and things we're invited to do. And so that's basically it.
Yeah, I mean, we I think really started this in earnest. Like
Ryan, somehow you're very soft.
oh, I'm sorry.
In your,
Yeah, I would say we really started this in earnest like during the pandemic. And
right,
trying like the first thing that we wrote together was what eventually became a Atlantic op-ed. And so that was just a sort of effort to uh, you know, find something to do during the pandemic. So we wrote that piece, and at the time, it was not like super well received because the politics of the moment hadn't quite shifted. And so then from there, we pivoted to writing the democratizing piece as a way of substantiating the essay intellectually. And then Ruth Bader Ginsburg died, and then we were off to the races. So
right, right. I forgot about the Atlantic piece, but
So another question is about how, Sam, your arguments about gerontocracy are also, part of your argument in your work with Ryan, if there is an intersection between both projects.
I'm not sure. I mean, I haven't shown Ryan the manuscript, so he should be the judge, but I think there's a connection insofar as at least part of the project is analyzing this long tradition of rule, not just through um, kind of elders, but through councils of elders, of which I think the Supreme Court is one kind of holdover from the archaic and classical past. So that's one clear connection, and I do give a lot of attention, as some other scholars have, to the age of judges and the consequences of life tenure, and indeed the debates in the Federalist Papers against the New York state arrangements at that time that did have age limits, um, as half the states still have today, on holding a judgeship. But there could be another, maybe there's one tension which a number of people have pointed out to me, which is that a lot of some of the work is about mechanisms of curtailing the gerontocratic effect in voting, because just the empirical reality, once you look at how far the uh, older voters control the electoral system, is incredibly, I think, disturbing. And so it calls for some experimentalism, which some have said is in tension with, a kind of, like, I think, naive picture that people have of Ryan's and my approach, which is basically to let whoever wants to vote, vote, and that's where the country goes. Whereas the Gerontocracy Project calls for interfering with the electoral system, including one person, one vote principles, in order to confront this, grim picture I mentioned earlier. But I think they're basically consistent. So I just thought I would mention one possible tension. I mean, they're very different kinds of work, because one's a trade book, which is, it's pretty, it's pretty academic at times, but it's nothing like a law review article, and there are very few footnotes and that kind of thing. So in part, it's just a different topic and a different genre.
But sorry, which one is a trade book? The
The Gerontocracy book. I mean, we don't know the ultimate form, or even whether it will exist, the of Ryan's and my book together. It could be a trade book, or it could not be a trade book. I sort of feel it wouldn't be, just because looking at some of the trade books that are now like coming out from the presses about the Supreme Court, um, yeah, no comment about their quality, but just the sacrifices required for us who are basically theorists in this project to speak to the people are maybe too great. And our goal in the academic work has always been to address law professors and only some members of the interested public. Not that there's no place for more vulgarizing, scholarship, but I don't think we've done it except in these journalistic pieces.
And so another question is about what kind of criticism you have been receiving. So I had a Russian professor who always asked us after, his lectures, whether we had any kind of emotional reactions about what he had just said, and perhaps what kind of reactions, emotional or not, have you received?
Yeah, I mean, a lot of, I think on the one hand, I think our work has generated a lot of enthusiasm. I think from an audience that was more like frustrated with more sort of orthodox response to the sort of institutional crises that we see in the U.S. politics. On the other hand, there are a lot of very negative reactions from people, especially I would say within the con law tradition. Like I think it's notable, and again, this goes to the freedom of the legal academy, but I think it's no accident that neither Sam nor I made our professional reputations as con law scholars, like writing, needing to impress, trying to like sort of integrate ourselves among a sort of narrow set of legal academics who identify as constitutional law scholars, writing doctrinal pieces about Supreme Court decisions around the 14th Amendment, First Amendment, things like that, right? We worked in very different traditions, but as sort of theoretically interested persons, like had thoughts about the role of the judiciary and so on. And so, for that reason, I think we were able to present a very relative to that tradition, an orthodox position, at least circa now, on some of these problems. And so maybe unsurprisingly, that then, does sort of ruffle the feathers of the more establishment figures. It's also been really interesting to see like which pieces like provoke really strong reactions and not. I have to concede, I'm not, I haven't been the best like predictor in terms of like which things will make people really mad and not. Some things make people very mad, other things less so.
Yeah, I agree with all that. I mean, I think I would say in among fellow scholars generally our positions have been rejected, but it was known going in that that would happen, and indeed I think we would have been disappointed had we received anything else than fierce resistance because we really were trying to attack a whole field and claim it had lost its way. I've done that many times, but like so I'm used to that treatment, and indeed, like that's my goal is to get it. But in this case, I think the timing was right, or our work was the result of these historical uh, you know trends that were also leading a lot of other people in a similar direction, fewer within constitutional law than outside, since there was a massive progressive interest in court reform, and including like big, cause groups organizing intellectual fora in which we both were involved. And then there's generational change among law professorships, and some of young uh, professors are much more interested than some of our elders. So, which is again bespeaks the relation of age to intellectual change, or political change generally. But anyway, so I think we have gotten our fair share of pushback. We're getting a lot of pushback now, actually, because we're seen to have attacked the very, bulwark of freedom, saving us from Donald Trump's, assault on the Constitution. And it's not like that's at all to us interesting as a kind of pushback or surprising, but it's hegemonic right now to the extent anyone addresses us. So that makes it, worth considering and potentially engaging. And um, I think the left is a lot quieter about the problem of courts right now. So court reform is on the back burner. And we'll just have to see how American politics evolves.
So, Arna, Pedro, and Tadeu, if you have any more questions, no pressure in any event, we can end the meeting before, if not. But if I can ask you both a question that, I have been working on defensive or militant democracy from an intellectual history point of view. And I have been seeing many German scholars here in the US defending the necessity of a more defensive democracy in the US and the role that the judiciary should play uh, in their conception of defensive democracy is a very, you know, is a considerable and powerful role. And at the same time, I see many left-wing commentators here in the US use Brazil as an example to say, look, if our Supreme Court was so powerful, if we had an electoral court as well, that would not be happening here in the US. So I have been seeing many people saying on Twitter X things like, make America Brazil again, things along this line. So my question for you both is, what do you think about defensive democracy from this point of view? Especially given the role of the judiciary, most conceptions of militant democracy as, the entity responsible for, defending the Constitution against its enemies.
Well, this is a great topic, and I did an interview that was released 2 or 3 days ago with a website called RevDem about German militant democracy in theory and practice, because absolutely they're in the face of the alternative for Germany, they're totally leaning into that tradition even more than before. I mean, I personally have been skeptical about it in the American form in relation to the 14th Amendment, Section 3 controversy, which is one of the topics I didn't dragoon Ryan into when I was asked by the New York Times to write about it. But my own view is cynical that like judges are overrated as defenders of democracy, and insofar as they're defending the Constitution, first they get to decide what its content is, which is effectively the power to rule, and often it's really a way of promoting some uh, like controversial understanding of liberalism or liberalism as such over alternatives. In the name of preserving the regime. But my main skepticism about militant democracy is more like strategic, that it might be that that there are obviously enemies of the Constitution or freedom or whatever. I mean, we're enemies of the Constitution. I like to say that, I told my students when Donald Trump tweeted "terminate the Constitution" that it hits different when I say it. But no, I think the basic, if clearly the constitutional order, even the terrible one that we have in the United States now, would be preferable to some alternatives. And then the question is, are judges likely to choose those like better rather than worse alternatives? And my basic response has been unlikely. To the extent it's likely, I think there's this very basic problem identified in German debates, that when you can contain an anti-democratic threat, it's not necessary to yet because the threat is too weak. So a good example would be like the threat the Communist Party posed to West German constitutionalism. And then when the threat is strong, it's kind of not feasible for judges to shut it down. because it's likely that it's just too popular for mere judges to fend off. And so there's this like paradox that militant democracy is feasible but unnecessary, or necessary but not feasible. And so that's my general reason for thinking that it's mostly a smokescreen for, illicit power grabs, but to the extent it's valuable, it's not available.
Okay, so one more question, perhaps. People would like to hear more about your criticism of judicial review.
Just in general.
Yes.
Yeah, I mean, I guess the sort of, I always say that our the sort of slogan for our work is that judges are bad, right? And in particular in the U.S., I think sort of history bears that out. I mean, so a lot of, I mean, as Sam said, like the first scholarly piece we wrote was called "Democratizing the Supreme Court." And I think that in that animating concept of democracy has been basically the conceptual framing for our work, sort of arguing that much of the work of courts, in particular appellate courts, and especially the Supreme Court in the US, consists of politics and the issuance of political decisions that are more properly assigned to democratic fora. Like that's the basic thrust. Like especially the U.S. Supreme Court, most of the work it does is just uh, resolving contested policy questions within the republic. And once you conceive of the work in that way, as my former colleague and friend Brian Leiter describes the Supreme Court as a super legislature. Once you conceive of the Supreme Court as a super legislature, that immediately gives rise to a legitimacy crisis, right? Like why would you want to create or how would you defend a super legislature that is insulated from democratic checks, right? To make the most sort of many of the most critical decisions within our republic. And so most of our work has been sort of, trying to uh, sort of ground that picture and then sort of ask like, okay, well, what would an alternative look like, right? What would it look like to reallocate decision-making authority within our system of government to more democratically responsive actors?
I'll just add that Ryan's point, transcends judicial review. And I think one of the things that has been kind of evolving in our own thinking, or at least emphasis, is how central we should make the problem of judicial review in the first place, because that's just one dimension of the interpretive power that judges wield even when they do not overturn or invalidate statutes. And so we've done a subsequent piece that just came out in Michigan Law Review called After Courts, which is just about how toxic judges are even when they stop short of invalidating legislation. And so that's all of the concerns he raised are directly applicable to like judicial activity generally, in at least in some important subset of cases.
So, no more questions, I think. So, thank you very much. Oh, I can ask you, is there anything you'd like to say or ask each other before we leave? So, no, thank you very much, Sam and Ryan, for accepting to talk with us. And yes, I hope to see you both in person. I met Sam for the first time online, Ryan as well. I have never seen you in person, but I'm very, very grateful for you taking the time to be here today. So see you hopefully in person next time.
Absolutely. Thanks for the invitation, Geraldo.
Thank you.
Okay, have a good day.
You
Bye.
too.